to give is the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat. It's good to see you again, Judge Keller. I'd be happy to hear any opening comments you have.
Good afternoon, Chairman McDonald, Senator Kissel, Representative O'Neill, and other distinguished members of the Judiciary Committee. My name is Christine Keller. I'm from Hartford. I first wish to thank Governor Rell for her confidence in nominating me for reappointment to a third term as Judge of the Superior Court, and I thank you for your time in considering my qualifications today. I was first appointed to the bench by Governor Lowell Weicker in 1993. Prior to my appointment, I had served 4 years as a family support magistrate in many parts of the state. Over the past 16 and a half years, I have presided over cases in all 4 court divisions: civil, criminal, both Part A and Part B, family, and juvenile. I have served in the judicial districts of Waterbury, New Britain, and Hartford, and was the presiding judge of juvenile in the New Britain and Hartford districts. For the last 3 years, I've been assigned to the Hartford Juvenile Court. I was chief administrative judge for the juvenile division from 1997 until 2002, and resumed this position in 2007. I also served as administrative judge for the Judicial District of Hartford. I am now, or have been, a member of numerous committees and task forces to improve the courts and the juvenile justice system. I've also served as a faculty member at the Connecticut Judges Institute. It has been a privilege to serve as a Superior Court judge and to work collaboratively toward improving and expanding our juvenile justice system and our courts with my colleagues and many other dedicated and talented persons from the judicial, executive, and legislative branches, local towns, advocacy groups, and the private bar. The work has always been interesting, diverse, and rewarding. I would be grateful if this committee and the General Assembly deem me qualified to serve another term on the bench, and I'll be happy to answer any questions that you may have.
Well, thank you very much, Judge, and we've had an opportunity to talk over the last several years about a lot of issues relating to the juvenile justice system. First of all, I wanted to get a sense from you of what your level of involvement thus far has been in the pilot program in Middletown, and what, if you could give us an update of how it's going under that pilot program.
Right. Well, I was a member of the Pilot Access Advisory Board, which was created when the legislature passed the law to allow the Chief Court Administrator to create a pilot program in a single juvenile court that would make the proceedings more open to the public. We started meeting in the early fall. A rule was drafted. I had some participation in the drafting of that rule. The rule was presented to the Rules Committee of the Superior Court. A rule was approved. However, because rules take time to put into effect, you have to have a meeting of the judges and all the judges have to vote. What we did was we adopted a standing order and put that into effect, which mirrors the rule that's proposed. The court selected was the Middletown Child Protection Session because it doesn't have a commingling in the waiting areas of delinquents and child protection, and the statute only contemplates opening child protection proceedings and not delinquency proceedings to the public. It also has the most interesting cases, the kind of cases where by watching a case you would learn the most, or watching the trials there you would learn the most about the system and how the system operates. We have 3 judges there now. The pilot started this week on Tuesday. There was a member of the press present on Tuesday. She observed the proceeding. The proceeding went to agreement. And we will be surveying the participants at Middletown for the rest of the year. And we have a survey that's accessed online. We're surveying the parents who participate, and the lawyers and the DCF social workers and any of the parties, as well as the staff. And we will be interviewing the judges and asking the judges for their opinion more towards the end as it progresses. We will evaluate it to see if it's had an effect or a perceived effect. And so far, it's only been 3 days, It seems to be working very smoothly. It took a lot of time and effort, and I really do have to thank the other members of the advisory board and the chief court administrator and the co-chair, Sarah Egan, for all of the effort that went into it. We did a lot of research. We looked into how a lot of other states do it. We actually compiled a little list of how they do it in all other 50 states. And you would be surprised to know that what we came up with by way of a standing order is probably a more liberal open rule than we have in most states.
Well, I appreciate that, and I would appreciate it if you would just periodically give us an update. We, oftentimes past legislation, we think it's a grand idea when it's passed, but we don't necessarily always get the feedback necessary for us to reevaluate the success of programs, particularly within the judicial branch. So if there are things that work particularly well, we'd like to hear that. Perhaps even more so, we'd like to hear any suggestions that we might do on the legislative side to facilitate the process. But I want to congratulate you and the advisory board for what appears to be a very fine product thus far. So thank you. With respect to we were talking earlier about the effects of a lot of budget cuts in the criminal division, but we haven't heard of what it means, if anything, within the juvenile division. So could you just give us an update on what challenges, financial and logistical challenges, have resulted from the budget crunch?
Well, I think in juvenile, since I came back as chief administrative judge, we have been asked to do a number of additional things. Let's start with the FWISN changes that were enacted in 2006-2007. We followed the law. We put the changes into effect. That was not so problematic. We had to, obviously it requires a lot of changes in forms and training of the staff and training of the judges and explaining all of the changes. But since that law, and now it's been on the books 3 years, over 3 years, the law does contemplate that high-risk family with services needs children who are referred to the court are able to go to what we call a family support center. We were able, with the money that we were given, only to open 4 of those. We had contemplated opening 6 more. So right now we have family support centers that are doing a wonderful job serving high-risk status offenders, not delinquents, in Waterbury, Hartford, New Haven, and Bridgeport. Actually, I stand corrected on that because some of them have actually taken some delinquents and served them as well. We don't have them anywhere else in the state, and that's money that we haven't been able to utilize or get enough money to put that into effect the rest of the state. So we have that law in the books now for 3 years that's really not being fully implemented. On Raise the Age, and I just want to say here that the efforts of all of the people that work for the police, judicial branch, public defender, prosecutors, to get everything going when we didn't really know the final version of the law until October were just tremendous. It took a lot of work to change forms, address some of the problems that have been raised by the questions that come up by various interpretations of the statute. And the law we have it up and running. What I'm seeing is about a 20 to 25% increase in cases based on 16-year-olds now coming to juvenile court. I'm seeing a slight increase in what has been an average number of detainees in the detention center. I'm starting to see a little bit of a bump in that. I was asking judges today, and it is still very early because a lot of our cases are just coming in now, and they're not really going to go to disposition until February, March, or April. Whether anyone's seeing any longer waiting lists for some of our services. I'm not seeing a problem with Riverview admissions. I'm not seeing a problem with residential placements. The wait is still about the same as it was before, but it still is a little bit early to tell. I'm starting to hear that waits for a lot of our wraparound services the multisystemic therapy, the services where we put therapists in the home with the parent and the child to work with the family. I know that we lost some beds, or some slots, not beds, for ICAPS, which is an intensive program that usually addresses delinquents in the home, but there's a substance abuse issue as well. So we lost some money there. We also had plans, obviously, to expand our services. We were hoping to have some vocational programs for the older kids, get them involved with a summer job or some kind of employment training program, because we're really trying to stress positive supports, positive things for the kids to do. So if you put a kid on probation, it doesn't have to be all punitive. We might be able to find an arts program if we find out that the child is really interested in art. So we weren't able to do what we want to do, but I think we're doing okay. I really do. I think that people are working harder with less. People are really making an effort. And merging with this was this wonderful collaboration that's developed. It started with Judicial and DCF, but now we have advocacy groups, youth services bureaus, juvenile review boards, legislators, State Department of Education representatives, and representative even from the Association of Police Chiefs. We are working toward more of a grassroots approach to the problems that we see here. I think it was Judge Damiani, or was it Judge Alander, who mentioned when he sat in juvenile, he didn't understand why he saw so many kids from New Haven and so few kids from a place like Woodbridge. Well, one of those reasons is that those wealthier, and I have the same, I can say the same in Hartford. I hardly ever see a kid from Glastonbury. Why? Because Glastonbury always had a juvenile review board. Hartford, Bridgeport, New Haven never had them until a few years ago. They sent most of their kids to the juvenile review board rather than sending them to court. What I would like to see is more, what we're trying to put together are teams in all 13 districts. We've already done that. We've already designated lead community agencies that are meeting to gather all the resources in the community so that when a kid gets in trouble, everybody knows what the alternatives are. Is it always court? No. Could it be a juvenile review board? Yes. Could it just be some counseling for the family? Would that be enough? Yes. Because I think we need to divert kids more away from the system. For some reason over the years, the court became the first resort, and the court should be the last resort, because every town should be willing to step up and help these kids. And we're also involving the schools and trying to get them involved in the process too. Friday morning I'm going to a meeting at Pope Park in Hartford, which will be the first meeting of the Hartford District Local Implementation Service Team, which is going to be headed up by the Hartford Youth Services Division. And that's going to involve, people have been invited from East Hartford and all the towns that feed into the Hartford Juvenile District to work on diversionary approaches. So I'm very excited about that, and I hope it doesn't peter out and doesn't turn into just another experiment or a good idea that didn't work. And I'm asking my judges to attend their local lists and encourage this. And, you know, it should be that we think of what could we do first before we send them to court, not let's send them to court because that's the only way they're going to get help.
Thank you very much, Your Honor. You know, I should mention for the other nominees and the members of the public that people are, you see a lot of members coming in and out. We were closed last Wednesday because of the snowstorm, and almost every committee in the General Assembly seems to be meeting today. I'm on 4 committees, and all 4 committees of mine were meeting today, so people are running in and out to go attend to other meetings. And so just bear with us as we try to. Senator Kissel.
Thank you very much, Mr. Chairman. Judge Keller, great to see you.
Nice to see you.
You know, you have all these years on the bench, and you've taken it under your wing to go with these reform movements, and I know how tirelessly you work in so many areas, and I've seen the really good days, and I've seen the frustration with trying to change the nuances of the statute to fit where we are at a certain point in time, and knowing that 2 years down the road we'll be at a different point, but we have to comport our statutes to comply, and it's a difficult task. My one question is, and I really appreciate the view from 30,000 feet as to where we are right now. And it sounds like you're doing all the hard work, the mechanics from the judicial branch, but you're going in the direction where I think we as a state have to go. and that is whatever we need to do to rescue these young people. Yeah, they've gotten in trouble and things like that, but all the alternatives first, the court last, not the court first, because that's the only place that they can get them to where they got to go. How can we as a legislature, you said, I hope it doesn't peter out. I feel the exact same way. There's been an awful lot of effort between the three branches to make this up and running. We've changed our statutes. Granted, we hit the brick wall of this recession, but at some point, maybe it'll be 2 years, maybe it'll be 10 years, who knows how long, but we will get through these clouds and we'll be on the other side, and we have to be ready for that. How can we right now, we have you before us right now, but today will come, today will go. How can we as a Judiciary Committee and we as a legislature keep on this to make sure that it doesn't peter out, that if there's nuances, little changes that have to be made, granted, there is no pot of gold. We're going to be scrambling. But I think that everybody in the state of Connecticut that has an ability to, wants to make things work, be better to the extent we can. We know that we don't have unlimited resources. We have dwindling resources. So how can we help you make this as good a transition as possible at this point in time?
Well, I mean, one of the things that I was sort of surprised to see, I sit on the Juvenile Justice Advisory Council and I serve on the Disproportionate Minority Contact Subcommittee, and one of the things I learned was that 1/3 of all delinquency arrests come out of the schools. And I think that, and maybe there's a good reason for it, maybe there isn't, and I know it's a very difficult job to be a teacher and to try to deal with some of the problems that we have in our schools these days, but I think for a long time there was a little bit too much of an overreaction to some of the things the kid do. Because sometimes I'd have a kid in front of me and I would think, when I was a kid, when kids did that in school, I don't remember anybody getting arrested. I remember the vice principal coming out and grabbing the two boys who were fighting by their shirts and knocking heads together or something like that. But I don't remember anybody being arrested and sent to the court. And I think that the zero tolerance kind of movement, which I'm hoping is dissipating, kind of contributed a little bit to that rise. But our delinquency numbers are down. There's a lot of things going on in terms of training police to take a sort of an easier approach with kids. The Juvenile Justice Advisory Council, as a matter of fact, is getting some national recognition for a training program that Connecticut developed to teach police how to interact with youth so it doesn't escalate and become an interfering arrest or a breach of the peace arrest or, sort of a disrespect to the police type of an arrest. And I agree with Senator Coleman. I sat criminal, and I still sit juvenile, and I see police reports, and, it's almost like it didn't have to get there. Or why was the approach even made? I think there's a lot of quality of life developed where everybody was concerned about the quality of life, but when I sat criminal, I was seeing a lot of arrests for loitering, or they're loitering. Were they really loitering? But they go up, and then it becomes sort of a fight, an in-your-face kind of thing, and then somebody gets arrested. You need to put more money into programs that help people. The other day I asked a question on the Child Poverty and Prevention Council. We were listening to people from the community colleges, and they were saying how inundated they are with kids now because kids are going to community college as opposed to the more high-priced four-year colleges. And they're losing staff, and they don't know what they're going to do. They think they're going to reach a breaking point where they really can't. It's going to take a long time to get your credits. It's not going to be 2 years. It might be 4 years. And then I asked, are you offering any kind of community college-type programs in the prisons? Because I know they used to. And they said, no, we were doing that, but that was with some federal money. We don't have it anymore. We're not doing that. I mean, your prisons should be helping people. They should have substance abuse programs. They should have college classes. They should be giving them some hope, some kind of job training. They shouldn't just be housing people, having them sitting there, not doing anything. Your kids in the schools, you have to reach down to the really low levels in the schools. The kids I see haven't been truant just this year. If you go back to their kindergarten, they've missed 45 days of school for the last 9 years. Why isn't something being done about that? You know, in some towns, they're starting to experiment. Stanford's doing a wonderful thing. They call it the PASS program, and this came out of the sort of list development that I just talked to you about. Now they're watching. 4 days out, they have a meeting. They bring the parent in. They go, what's the matter? What's wrong? Why, if the kid doesn't like a particular school, why can't schools be a little bit more flexible? We have all of these magnet schools and pilot schools and private programs. You know, there's just so many things that could be done early on so you wouldn't have the problem that develops when they're 13 or 14. Because to me, the worst thing that's happening, and the reason that they have so little hope, is that they lose interest in school for whatever reason. They don't catch up. Boys may not be being taught the correct way. There's a lot of studies on that. I mean, I think you really have to focus on the schools, and I know the schools don't want to see unfunded mandates, but if you could give them the money to do more positive behavioral support systems in the schools, I know we're doing that in Bridgeport, I know it's been very successful, make school a place where the kid really wants to go and a place where the kid knows that he can get help and no one's just going to ignore him or have him arrested. Don't make some schools just warehouses for all the bad kids. I think the earlier you start, the better. The same thing goes true with infants. When you see infants in trouble, someone has to do something.
I very much appreciate that. I went to a summit a couple of years ago, the governor's summit on, I think it was early childhood education. There was an expert, I believe, from Hartford that showed the development of the brain and how, you know, things really early on, 1 year, 2 years, 3 years old, can really set a child back. And, you know, who can blame some children if they are set back in 4th or 5th or 6th grade? If you know you're never going to be able to catch up, why keep playing the game? You know, if you're just destined to lose, quit. That's actually a very human reaction. So I hear you. I know that in the town that I live in, Enfield, there was a meeting recently between social service agency folks involved in youth services, the schools, the superintendent, and a lot of people in the town that have an interest in trying to get our arms around this, the truancy issue, the rebellion, and trying to figure out a way, because it's the folks in the school system that are recognizing that, you know, there's limited options and how can we maximize the outcomes. So that was a great answer. It just shows where we need to go, and then it does start from the earliest stages. The last question that I have is, I've heard that youth crime is down, but that violent youth crime is up. Where does Connecticut stand regarding that? Is that just anecdotal? Is that national? Do we fit into that, or is that just not true at all?
I have seen statistics that say that crime is down, but serious violent crime is up. I'm not sure that I'm seeing that in the Hartford court, but I can't really answer that with respect to delinquents, whether we have more serious delinquencies. We don't, you know, you might see that in a rise in transfers, because the more serious cases that involve guns or serious violence might end up being transferred to adult court. But our transfer cases are actually holding at about the same amount. I think they're a little bit lower. And now a recent appellate decision requires the judge to actually make the decision on the discretionary transfers, and I think you're seeing those are going down a little bit because judges are making a decision not to order the transfer. So.
Well, Judge Keller, I just can't help but commend you. Happy to support your renomination. I think you've done a tremendous job. You've gone into a lot of areas where maybe some other judges wouldn't want to take on as many roles as you've taken on. It certainly has to keep you busy all the time. And I'd like to believe at the end of the day that even though we're in the midst of this deep recession, that we're putting things in motion that 10 years from now we'll look back and we'll say, we were a little bit prescient when we did that. We made the right decisions, because very few people I'd like to give up on, and certainly our young people I don't want to give up on. And sometimes even the smallest changes can have major ramifications at the end of the day. And so thank you for your service to the people of the state of Connecticut. Thank you, Mr. Chairman.
Other questions? Representative Walker.
Thank you, and thank you, Judge Keller. Thank you for being a good partner in this process, and thank you for all your dedication. The one thing I have to say, you taught me a lot about law, a lot. More than I even thought I was going to be subjected to in some
You even
regard.
said one day you actually were developing respect for lawyers.
Yes. That was But I couldn't agree with you about some of the things you talked about. Our family service needs centers we need to find the funding for those. They have been a wonderful asset in trying to reduce the delinquency out there. I've been to a lot of them, and they've done a great job, and our numbers are down. And it also put ownership on the schools, too. And that's been, I think, the best end result of this whole juvenile justice reform in Connecticut has been that everybody is now around the table. I know Representative Lawler always said, make sure that everybody's there, you have every seat filled in order for you to really get honest reform done. And you have helped make sure that all of them have been there. And I'm on the list in New Haven. Okay. And we're going into our second meetings too. And the one thing that I have to say, which we haven't had, is we have not had the judge there yet. So I'm just giving you an intro to that. But thank you for your dedication. Right. And I know that we've got a lot of things to go. In fact, I did speak to Judge DiMignani earlier, and one of the concerns that we've had has been what has happened to the youthful offender status with these changes. And he explained to me that we have a maximum of 4 years now with the YO. Otherwise, it has to go to an adult court. Because we had a case in New Haven where the young man, this was his first arrest, and I'd been in contact with some of the parents, and we talked about some of the issues. And he said he couldn't go for YO status because the prosecutor said that he was thinking of trying to go for more than 4 years, so therefore he could not go for YO status. So I'd like to look at that with you as we start to make some of the changes that we go forward in this to try and figure out how we can salvage it, at least for the 17-year-olds going forward, until next year when we raise the age to 17. Okay. So thank you for your efforts and all your hard work and your sleepless nights.
Thank you.
Anything further? I'm sorry, Representative Gonzalez had her hand up.
Thank you. Good afternoon, Judge.
Good afternoon, Representative Gonzalez.
I was checking on a press release from Judicial Branch.
On the what? I'm sorry.
Press release on Judicial Branch.
Yes.
It came out in 2007. Mm-hmm. And here says that you was appointed as a family support magistrate in 1989.
Yes.
Okay. My question is, when you got appointed as a judge, as a magistrate judge, do you have to come 8 years for reappointment?
No, the magistrate position, and I think this is still true, is it's a 3-year appointment. The governor appoints you. There's no vetting by the Judiciary Committee. I think that's still the case, correct?
No.
No?
No, we changed one.
No, I don't. Did we? No,
We changed
it didn't
that?
pass.
It didn't pass?
So after 3 years.
You don't know what you just
wait.
opened.
Wait.
She asked the question.
I have a question.
After 3 years, the governor reappointed me.
Why didn't it pass?
And that's all. That's what it takes to.
That's what it takes it.
Right.
So that means that then in 1993 you was appointed for the Superior Court.
Right.
Okay. So after 1993 you have to come back 8 years later
It
for
was an
reappointment.
interim appointment in 1993. I was appointed in August of 93, and you weren't in session, so I had to go up again in March. So my full 8-year term, the first 8-year term, didn't actually start till March 29th of 1994, but I actually sat on the bench from August of 93 to March of 1994.
Yeah, because I was saying if you was appointed at 1993 as Superior Court, that means that you were supposed to be here 2009 for reappointment, not 2010.
Well, no, because I had an interim appointment, then I got my first full appointment in March of 94, so I came up again in 2002, and now it's 2010.
Okay. I was checking on I'm not going to ask about the question 25 because
Okay.
I'm not going to ask about that. I'm going to ask about something that is not there. And based on some information that I received and some phone calls, it is a defendant that 2002, his lawyer was Don Caldwell. And he passed away, and then his brother took over. The defendant, the lawyer told him, you have to plead guilty because if not, you have to go to a trial in 24 hours. The defendant, he got scared, and he pled guilty.
Mm-hmm.
But then, the same day, he found out that the lawyer was he was ineffective. And he went in front of you to change the plea. And you denied that. You denied the right for counselor of choice. And after today, he still complain about that because he's saying that you violate his dual process. And I would like to know, what is the process? What is the process in court if I plead guilty,
Yeah.
and then I want to withdraw that plea?
Yeah.
What is the process? Do I have the right?
Well, you don't have an automatic right. There's a standard, and you have to review whether or not there was any reason to believe that the plea wasn't made voluntarily, knowingly, and understanding the full consequences. And if you don't find that, then you don't vacate the plea. I'm sorry, I heard several motions to vacate guilty pleas. I know I vacated several. I know I denied some. So I'm not familiar with the case.
I think that
It's
in
not
his
ringing a
record,
bell.
in his record, there was some pictures about him with some politicians, and I believe based on his letter that you kind of criticize what you're doing with this, political pictures. But anyway,
Oh, now I know who you're talking about. Yes.
So the case, I was very concerned because I said, if I plead guilty and I decide to withdraw the plea,
Right.
And the judge is going to deny me that's my right.
That gentleman was going to be tried, and he pled guilty, and I took the plea, and I know I canvassed it thoroughly. That gentleman was convicted of taking money from people. He went up to people in the hallways of the courthouse and pretended to be a lawyer. He wore a suit, and he carried a cell phone, and he told people he was a lawyer, and he took money from people, and he took money from poor people who were in desperate situations, who were charged with crimes, and he told them that he had an in with judges, and that's how he would take care of their case. And then it turned out that it was all a fraud, and I did take his plea, and I did not find any reason to vacate his plea. And I do recall during the sentencing that he showed me pictures, and he had showed me pictures of himself with several people who were politicians, and I think I said something to the effect of, since you're aware of my background, that showing me pictures of you with politicians, I'm probably one of the least. I'm not really affected by that. It's not going to intimidate me or make me feel that I have to be very cautious because people who are politicians, because I'm one of the judges who happens to know a lot of politicians too. So maybe I said something to that effect. But later on, I saw that gentleman. He had been released, and he came up to me in the legislative office building, and I think he has a job, and he thanked me for what I had done ultimately, and said that it had served. He had learned his lesson, I guess.
I received this yesterday.
Oh, I'm
but,
sorry.
Yeah,
but
another question is, it's about DCF. DCF, it's a law that says that if the workers, DCF workers, they're going to remove a child from home, they have to prove that they did everything in their power to keep the family together. And I have a memo in my office that we know in our community, and we know for experience, that DCF workers, they lie to the judges. They lie to the judges because some of these workers, they don't do everything in their power to keep the family together. Because it's a federal law that says you have to prove the court that you did everything in their power. If not, they don't pay the federal, they don't pay the workers, the DCF workers. And a lot of people in our community complain about that. Well, wait a minute, they're a family, they want to, keep the kids, they don't go to us, they don't listen to us, they remove the kids, they totally ignore us. Okay, now, saying that, I always complain and I always say that why, if the workers, they lie to the judges, and I know they lie, but you will say, well, we believe in them. I think that it got to be a way that if they don't do everything in their power, but they want to prove the judge that they did because they want to get paid, and I saw a memo that you said that to the judges that they have to sign to DCF workers, when they said that they did everything in their power to maintain the family together. Mm-hmm. And that memo, when I saw that memo and I was checking, I said, but wait a minute, if they can prove the court, because I know for a fact that they don't do that because they lie to the judges, why she sent a memo saying you have to sign to the DCF workers so they can get paid?
Okay. The federal law, Adoption Safe Families Act in 1997, requires that any child who enters foster care, it requires that the judge find immediately or within 60 days that the department either made reasonable efforts to prevent removal, did not make reasonable efforts to prevent removal, or reasonable efforts were not possible. And reasonable efforts may not be possible if it's an emergency and the child is at such imminent risk that the safety of the child would be so jeopardized by making any effort to keep the child in the home that you find that they were not possible. When an order of temporary custody is brought to a judge, we are required to make one of those three findings. So I would never tell the judges, you must find they made efforts. But they have to find that efforts were made or efforts were not possible or efforts were not made. If they find efforts were not made, then the federal monies, the reimbursement monies for foster care don't kick in for that particular child. But if the judge finds efforts were made or efforts were not possible, then the federal monies are not jeopardized. And that finding has to be made. We make it at the time of the OTC because that's the most important time. If you don't have an order of temporary custody, but you hear a neglect trial, and at the conclusion of the neglect trial, you decide that a child needs to be committed, then you make the finding at that point in time. But it is a required finding. It's required by federal law and state law.
Okay. And my last question is, and correct me if I'm wrong because maybe I'm not, but every judge runs the court. I said that Judge Keller runs the court. But let's say that I deal with housing problems. And if I'm dealing with housing problems, I'm going to be working in, let's say, Hartford court. Mm-hmm. And I'm supposed, and correct me again if I'm not right, but I'm supposed to help all the other courts. They got any problem with housing, they will call me and I will direct them, I will help them, I will give them advice. But I will run a court even though that I'm working especially in housing issues. And you as the juvenile, you in charge in juvenile, right?
I'm in charge. I'm the chief administrative judge for juvenile. I am not the presiding judge in Hartford.
So you're not the presiding judge?
Judge Danahy is the presiding judge in Hartford.
So that means that you're different than the others? Then the others, they run a court and also they specialize in different issues, or what is the difference?